Victim number 6.
Will you say that loud enough for the court to hear, miss?
You have to listen to us also. कैंची की तरह जबान चलती है.
Victim के कैरेक्टर को बार-बार क्वेश्चन किया जा रहा है. I just thought कि एक बार सब कुछ पूछ लेते हैं unless the prosecution has an objection.
You do not know your limits.
Answer my question.
Then better I will show you the example.
I asked you a question. You promised that you would answer me.
Behave yourself.
कोर्ट प्रोसीडिंग है, कोई गांव की पंचायत नहीं कि जो जब जिसने चाहा मुंह उठा के चलाया.
उसके बाद जैसे कि आपकी जानने वाले विश्वास कि आपके बहुत सारे और भी
Litigation is the mainstream of Indian legal system. The pendency of litigation is the main concern. It is estimated that the present backlog of cases may consume centuries to travel to its logical end. The cumbersome procedures and delay in courts are becoming inevitable. Hence, alternate methods are evolving to tackle these hazards and deliver speedy justice to litigants. Mediation is one such effective alternate dispute resolution and methods wherein the litigants, being chronic enemies, can turn friends through their own decisions and settle their disputes with proper support of the most modern mediation methods. To discuss on the same, we turn to Mr. A.J. Jawad, advocate and senior mediator, trainer, to throw light on aspects of mediation and preliminary discussion on the Mediation Bill 2023. Mr. Jawad has been in practice as an advocate at Madras High Court for the past 35 years and a dedicated mediator and trainer for the past 17 years. And his recent achievements in the year 2023, he has been a recipient of 3 awards in a row: the Arun Jaitley Award, Shri Sriram Pancho Award and Kamala Sharma Award for outstanding skills in mediation and towards his dedication towards mediation and being a superlative trainer.
Hello, sir.
Thank you, Rajkumar, for having me here today. It's a real honor to be here with you.
Yeah, thank you so much. We are also honored. We just want to know a lot of inputs from you so that it will be useful to the people and to the litigants.
Yes.
So 2005 was the initiation of
Court-annexed mediation. Court-annexed.
Towards mediation.
Yes.
So from that year, now we have nearly crossed around 19 years.
Almost.
So now we would like to know, because what will be the future and what has happened till now for the past 19 years. Because our country, like it is right from Vedic civilization, we have had Mahabharata, Ramayana, wherein Lord Krishna, Hanumanji, all were mediators. And once they failed, the war happened. And even in our Tamil Nadu, Avayar was a mediator, because Tondaman, Adiyaman, there was an episode where she averted the war through her own skills of mediation.
Yes.
So once here we see both ways, because the war has been averted, at the same time war also has happened because of the role of the mediator. Yes. So now you have been traveling all over India, so many places, and you have been having access to many people there, advocates, mediators, litigants, from Leh to Kanyakumari. So your vast range of travel. So we would like to know, like, still whether the impact of mediation is still prevalent in people. Is it alive in the people, or they're more aggressive and otherwise?
Well, that's a very, very deep question, actually. Now, first of all, I think I need to clarify some misconceptions. Because when you say that Avayar mediated and averted a war, you're right. But when you say that Lord Krishna and Lord Hanuman acted as mediators, it may not be right, because I think they were more of ambassadors. Because Lord Krishna was representing the cause of the Pandavas and Lord Hanuman was representing the cause of Lord Rama. So they went there as ambassadors, not as mediators. Because one of the first things that is required of a mediator is neutrality, which means that the mediator should be equidistant from both parties, in the sense that the mediator should not be a representative of either of the parties. Mediator should be neutral. So that is one of the first qualifications of a mediator. If we look at our ancient culture and compare it with what modern mediation actually stands for or how it works, there is a huge difference. But the commonality is this, that culturally we have always believed in dialogue, in having a conversation to resolve our disputes. Now, what happened was about 200 or little more than that, years back, the British came to India and they established today our court system. So our court system operates on a particular model which is called as the fault finding model. Because justice means, because what the British have done, they have laid down laws. Okay, so you have laws, and if you want to claim something which is rightfully yours, that claim has to fit into the framework of this law, and if it fits into that, the court will give you justice. Now, if you look at the definition of justice itself, I mean, if you look at the concept of justice, there is a huge difference between justice according to the law and complete justice. Justice according to law may not translate as complete justice. For example, if I owe you some money and 3 years have passed, you definitely have a right to claim that money from me, but the law says because it is beyond 3 years, you cannot go to the court and claim that money from me. So the court stops you from knocking its doors to recover the money from me. But my moral obligation to pay you the money still remains, and your right to recover the money still remains. But the only problem is your remedy is barred by the law. Now that is why I am saying that justice according to law may not translate as complete justice. That is one aspect of the problem. The other aspect is that we have embraced this system given to us by our colonial masters to such an extent that we have forgotten our culture of dialogue. Right? So what mediation essentially, the mediation movement, okay, and I thank you for being a part of this hashtag mission mediation, which I call it as. The objective of the mission mediation is to once again revive this idea of dialogue, this idea of negotiating your differences, having a dialogue over your differences and finding solutions. Now usually what happens is when people are in dispute, when they have differences between them, they are driven by various emotions. They may be angry, they may be suspicious, they may not trust the other person. So when they are driven by these emotions, it's very difficult to have a dialogue, and that is why you need a neutral third party who is called as the mediator, who will facilitate this dialogue between the parties. And for that, the mediators are trained to understand the emotions, to deal with the emotions, to help disputing parties to move beyond those emotions, look at their larger interests, the long-term interests, and find solutions that work for both. So mediation operates on a win-win paradigm. Okay, when I say win-win paradigm, it essentially means that neither you lose nor I lose. Whereas if you go to the court, one party wins, the other party loses. But actually, if you look at it from a very objective perspective, you'll find that both parties are losing. So
now, as you said, we are more on a colonial mindset. And even our legislations are based upon the colonial mindset. So we almost, even still, those laws are prevalent. Though some are not relevant today, even the amended ones have the replica of the older ones.
Yes.
So we have to think otherwise, but which is not happening. At the same time, we have so much of flooding of legislation, so many jurists think and they enact laws for the welfare of the people. The courts have to interpret and they have to bring it and they have to apply. There is no progress due to the procedural
wrangles.
Yes. So this being so, how do you think mediation can really help? because the legislations become meaningless, because it is like a panchayat. You have somebody who you call somebody, just talk, and you say don't talk law, just talk facts. I have been in some mediation sessions. No, don't talk law, don't talk on the merits of the case. Just talk facts and compromise. You leave all your rights, you think peace, tranquility, and how do you think that it can be so convincing for people? So they know that we are living in a system, but what happens is ultimately, though mediation says they are not forced to, but for a compromise they have to come to a certain terms. But why not we implement the laws in a more faster rate and get over this cumbersome procedures? So mediation can also, it can contribute to that extent. So what are your thoughts on that?
Okay, here's what I would like to say about that. Can the laws alone solve all problems? That is the moot question, because you may think of every aspect of a particular situation and formulate a law to deal with that situation. But ultimately it boils down to one thing. If I have a problem with you and you have a problem with me, a dispute, are we really worried about the law, or are we worried about finding a solution for the dispute? See, mediation operates within the framework of the law. Now, you and I cannot have an agreement that is illegal. Okay, that is there. So the law is helpful to the extent of defining our solution or helping us to frame a solution that can be legally enforceable. Right? Now, when you talk about justice, if you and I have a problem, and are we really worried about justice according to the law, or are we worried about finding a solution for our problem? Where should the focus be? That's a question we need to ask ourselves.
We have to say solution.
We have to see solution, right? So if we are focused on the solution part of it, then what stops us from sitting across like this, talking to each other with the help of a third neutral party who has nothing to do with our dispute, but who is able to help us to move beyond our misunderstandings and find a solution that works for both of us? See, today the problem is we are operating always on a competitive paradigm. We are always looking at things from a very competitive perspective about winning. Okay, we are even teaching our children about winning. Are we teaching our children to collaborate with each other? Are we teaching our children to work with each other to find solutions for a problem? Now, here is where I just want to, talk about a very simple concept called Ubuntu, which is prevalent in Africa.
Helping each other.
Helping each other. Basically, recognizing the fact that we need each other. We need to live peacefully with each other. There is a story regarding Ubuntu where there was a Christian missionary who was working in an African village, and he told the children one day that I'm placing a jar of sweets at the end of one field, and whoever goes first can have the entire jar of sweets. See, this is the Western paradigm of competition, because they always look at it from competitive perspective, winning, losing. Now, what was surprising was that all the children held hands with each other, they ran together, they took the jar of sweets and shared with each other. So he was surprised. He asked, why did you do that? And they said, Ubuntu. And he said, what is that? And they said that, how can I be happy when my friend is not happy? When Nelson Mandela was asked by the Western powers that we will give you everything to prosecute the apartheid regime of South Africa for the atrocities that they did on the black people, he said, I don't want to do that. And they asked him, why? They said, we are giving you everything. We are giving you the money, we are giving you the infrastructure. Punish them for what they have done. He said, Ubuntu. He said, that's not the objective. The objective is to live peacefully with each other. And that is how the Truth and Reconciliation Commission came to be established in South Africa. And if you read some of the proceedings, they're so moving. People were moved to tears. So that is how, we can survive in this world. Because when you see the conflict around us, you see the wars that are raging on around us, people getting killed, small children getting killed. Is that the solution? Is that how humanity is going to survive? Imagine the environmental impact of these conflicts. Imagine the humanitarian impact of these conflicts. So why can't we talk about it and find solutions?
So whatever you spoke is a very, very ideal situation. Like, we would love to be that kind of a situation, but actually it is not happening because of the diversified thinking, diversified nature of people, maybe religions, caste, communities, everything plays a role. Now, as a mediator, you would have met so many types of people, like in different communities, religions, because we have personal laws here and you will have to apply. Though we couldn't, you shouldn't talk about law, the mediation, there are certain values which we have to respect. So how do you overcome that? Like, how do you bring a solution to that? And how do you, if there is a clash in these kind of ideologies, how you need an expert for that, or even a normal mediator is sufficient? What is the training imparted?
Now let us look at it from a very practical perspective. Today we have 5 crore cases pending. Niti Aayog has given a report that if you have to dispose of these cases, it will take you nothing less than 324 years, provided no new cases come in. Now, one more statistic of Niti Aayog which they have given in, they came out with this ODR, the advantages of online dispute resolution. They came out with a booklet in which they say that 75 to 97% of disputes don't come to the courts. Now, where do these disputes go? Simply because people are scared to go to the courts because of the cost, because of the time. So either they go to some, what we euphemistically call as the Katta Panchayat or the kangaroo court. I don't want to elaborate who are all behind the kangaroo courts, but generally people go there, or they just live with the dispute because they don't want to spend that kind of money, and also the uncertainty as to whether we are going to get justice or not. So that is one part of it. So therefore, we need to have a mechanism, a legal mechanism, a legitimate legal mechanism by which people can come, sit together, find a solution to the disputes and go back with a solution that would work for both of them. Now that is absolutely necessary. Now what does a mediator do? What kind of training a mediator requires? Yes, a certain amount of expertise in the domain in which the mediator is mediating. For example, if you are mediating a dispute which relates to the family law, a certain amount of working knowledge of the family law is required. If you are mediating a dispute in a commercial contract, you need a certain amount of knowledge on how commercial contracts work. So that part of the knowledge is required. But more important is the process expertise. How does a mediator design the process to suit the needs of the parties so that the parties are able to move beyond their assumed positions? Because they come with positions. This is what I'm demanding. This is what I want. That is their demand. Now, what is it that they really need? What is the most important thing for them? And how are they going to achieve this? Because, for example, you're going to the court. Let us assume that you succeed after 10 years also. The question is, we have a saying, as a lawyer, you also will agree with me when I say this, that the problem of a decree holder starts only after getting the decree in his or her hands. Because execution of the decree to recover what is due to you is another process, which may take another 10-15 years, provided the other party has not gone in appeal and got a stay of the original order. So in all these circumstances, the simple question that everybody needs to ask is the bird in hand worth 2 in the bush? So all you have to do is take a practical and pragmatic view of what is the most important thing for you. Am I going to wait for the 10 crores that I'm going to get after 15 years? I'm not going to get the real money in my hand. I'm just going to get a paper which says that I'm entitled to 10 crores. Or is it worthwhile settling for 20 lakhs today? Because that is money, real money that is going to come into my hands, right? Now, pursuing these 10 crores, how much time am I going to waste? How much money I'm going to waste? How much mental agony that I'm going to go through? How many trips I'm going to make to the court, to my lawyer's office? Now, all these things, if you add all these costs, believe me, the value of this 20 lakhs will be much, much more than the 10 crores which you may or may not recover after 20 years. So it's a simple question of, you can even regard it as a simple question of maths, right? It's a mathematical question. It's a logical question. Why should I waste my time doing something, wasting my time and energy, wasting my resources, pursuing something which I may or may not get, when I have the certainty that this is what I'm going to get today? So each one has to ask themselves that question and take a call on whether they want to settle today or fight for the so-called justice much later.
So it is so discouraging to the litigants. Mediation has to step in.
Let us look at it this way. Okay, you know, in the medieval days, in Europe especially, there was a tradition. If I feel that you have dishonored me, or you feel that I have dishonored you, we challenge each other to the duel. We go and fight. So we draw our swords, we go to an open space, public space, and we have a fight over there. And whoever wins, that person's honor is vindicated. Now what we are doing today is, we are doing something very similar. You and I have a problem. The first thing we go is, today we don't draw swords and fight with each other. We engage champions. We engage our lawyers. So the lawyers go and fight in the courts. So whoever wins, whether you're right or wrong, doesn't matter. Because as long as you are able to legally prove your claim, you have won. Now let us look at it this way. That may be necessary. But before that, why don't we try to solve the problem? Why don't we try mediation? Why don't we sit with each other, have a mediator help us to find a solution, and if that doesn't happen, if that doesn't work, we go and fight. But at least we have a lot of clarity when we go through the mediation as to where we stand. We start looking at the dispute from other perspectives. We start understanding each other better. We may narrow down the scope of the dispute. Like supposing we have 10 issues. Even if 8 issues get resolved in the mediation and 2 issues we are not able to resolve, we can go fight in the court. But why do we straight away go and fight? Isn't it common sense, isn't it civilized to first sit and have a dialogue with each other and find a solution for that problem to the best extent possible? If that doesn't work, you go for that. To give you another analogy, if you have a stomachache, the first thing you do is take medicine. You don't go and tell the surgeon, please operate on my stomach. That is extreme. It's only when you have cancer, God forbid, or something. But you don't straight away go to the surgeon and say, please operate on me. You try to take medication and try to solve the problem. It might be due to acidity. You may even have gastritis, but that can be resolved through a problem. You don't need a surgery for that. But today, what we are doing is, because we don't have the facility of medication, also known as mediation, we are going for the surgery which is called litigation, the courts. So all we are saying is, go for the litigation if there is no other option left for you. Courts are important. Courts render justice. But courts should be free to render justice where it is deserved. Not to solve problems between 2 brothers, 2 sisters, husband and wife, business partners, okay, customers and business. Why should the court sit and decide all these disputes when these can be negotiated and resolved with the help of a neutral third party called the mediator? Why do you go to court for each and every problem? So today we have 5 crore cases and we don't have enough number of courts to dispose of all these cases. 324 years it is going to take you to realize justice in the courts. June 2023, I'm sure you would have read of a report where a man was released from prison after having spent 25 years in jail for an offense he did not commit. The sad part of the story was, father and son were convicted of murder. They were sentenced. 25 years they spent in jail. 25 years later, Supreme Court in June 2023 declared that they were innocent. The father walked out, but the son was already dead. He had died in prison. Where is justice? So why can't the courts render justice there? Why did the Supreme Court take 25 years to dispose of a case where a man's liberty, where 2 men's liberty was concerned? There are hundreds of examples. I'm sure you know better. Hundreds, thousands of examples like this. So free up the courts is what we are saying. Choose mediation. Try to resolve. If it doesn't work, go to the court.
So now, still, whatever we spoke, suppose you take up mediation. I don't think even on today's date, we do not have that kind of infrastructure which can lead people directly to mediation and resolve their issues. On date, we don't have such an infrastructure. So now people are pushed to courts and the concept of mediation has not been publicized, or nor it has reached the grassroots levels, because it needs wide blanket bombing. People should realize there is option of mediation, and how well it can be defined is the main thing, because even on date I feel that there is no proper definition, and which has not reached people as it has to be. Because if people are going to opt for mediation, it should be a clear definition. It should be totally publicized even in the cinema halls or in the papers and everywhere, because now we find it's all court annexed mediation, and the litigation only is sent to mediation, and people don't have a direct access to mediation. This is one part of my question. The second part, you said there are around 5 crore cases pending throughout India. So I think it is 4.4 crore cases are pending in the district courts, and 67 lakhs are pending in the high courts, and the remaining in Supreme Court. The majority chunk of cases are in the district courts. So is it not right that the mediation has to reach the grassroots levels? Now I see, because the conferences are held, many justices speak in the forum, and it is more of a elite, and we have mediation centers in the cities which resolve all top class elite cases, and the access is at least available for them, because they have mediation, arbitration, as well as Lok Adalat. Everything is all court annexed. Now there should be some lead for the people to identify such a forum of mediation. And is it not very necessary, because this 4.4 it's more of cases which can be resolved through mediation. So what are the steps now according to the new bill of 2023? Is there any access where people will be led to such a situation where they can help themselves?
Your very, very pertinent question, Rajkumar. Thank you for asking that question, because you are absolutely right when you say that today we really do not have the kind of infrastructure that we need to actually mediate all disputes that come for resolution. Now, but here's the challenge. We have come a long way, because when we started the first court annexed mediation center in Madras High Court in 2005, there was hardly any knowledge about what mediation is. Many people confused it with meditation. So when you put up a poster saying we have a mediation conference, the newspapers will carry that there is a meditation conference.
No, you even Google it.
Yes.
You get a lot of meditation.
Meditation techniques and other things that come to you. But today the situation has changed in India. Thanks to the efforts of the high courts, and thanks to the effort of the Mediation Conciliation Project Committee of the Supreme Court, Justice S.B. Sinha set up a Mediation Conciliation Project Committee known as MCPC for short. And they did a lot of work in promoting mediation in different courts. We had a conference in the Madras High Court where 2 of the Supreme Court justices, Justice Sanjeev Khanna and Justice B.R. Gawai, they attended. And there were about, I think, 17 mediation centers that were inaugurated in various subcourts. Now, as far as the courts are concerned, courts are putting in all effort, because courts realize that it is impossible for them to really deliver justice to the 1.4 billion people who are there in this country. It's impossible considering the kind of infrastructure that we have. And even if you address the infrastructure issues, it's not going to be very helpful. So we need mechanisms like mediation to resolve these disputes. So from that perspective, the courts have been working very hard. Now, if you look at where we were in 2005, and if you look at where we are today in 2024, we have come a long way. Today we have a law on mediation, where there is a provision which says that mediation service providers, because the idea is to promote institutional mediation, where the Mediation Act provides for the establishment of mediation service providers, which will be basically institutions or organizations or partnership firms or companies that will be rendering mediation services to people. Now, what is required today is informing people the advantages of mediation, and that is where the program that you're hosting today, we need many more programs like this. we need many more people coming forward to explain the mediation process to people. Now, my experience has always been that, in the court annexed mediation itself, courts are supposed to refer parties to mediation. It's mandatory. That's what the Supreme Court has said. So when they come for mediation, they come with a lot of skepticism. What is this? They don't even know what it is all about. And the lawyers, sometimes, some lawyers who don't know mediation tell them that, look, nothing's going to happen there. So they come. And they come and tell us that, look, we are not interested, we want to go back to the court. Please send us back.
Or they take time gaining tactics. 3 hearings they come.
Yeah, it may be. I'm not going into that now. I'm just saying that genuine parties who want to find a solution for their matter, but they don't understand how the process works, they come and say that we don't want to waste time, we want to go back to the court. And then I make them sit down. Me, not just me alone, many of my colleagues, we make them sit down and we explain the process to them. We tell them, just give us 5 minutes of your time. And we explain what are the advantages, how the process works. What they do is, invariably, they sit down and they take part in the mediation. Because they don't know. Till now, they have not known what the process was all about. And when the lawyers come to know that it is going to help their clients, they cooperate. I have, in my 15 years or 16 years of mediation practice, perhaps on 1 or 2 occasions I have come across a difficult lawyer who is stalling the settlement.
Yeah.
Okay, we normally, we impute lot of things to lawyers. We look at lawyers from a very negative point of view. But actually, lawyers are not bad people. They are good people. Okay.
Yeah.
We are good people, right?
You
You
have
and
to
me
say
are good
that.
people.
You
Yes.
have to say that.
No, you have to. I mean, it is a fact. It is a fact. See, lawyers also have their best, the client's best interest at heart. It's not always about the fees. If the lawyers realize that it is advantageous for the client to settle this, then they encourage the clients to settle it. The lawyers also know the weaknesses of the case, the strengths of the case. So they know that in a given situation, settlement is the best option for the client. So they advise the clients to settle. Now the challenge here is, the clients have to pay the fees properly to the lawyers. Just because the matter is getting settled and the lawyer has helped you in finding an easy solution and helped you to avoid a whole lot of expenses doesn't mean you deprive the lawyer of his fees. Pay the fees properly. But we have come a long way, the awareness is increasing, but it is not enough. Now what happened when the mediation bill was prepared? It mandated mediation. It said before you go to the court, you have to at least attend 2 sessions of mediation. Many Western countries have this model. So the same model was adopted here, but then it was realized that we don't have that infrastructure. So if you're mandating mediation, many parties may not be able to get relief immediately because they may not find the infrastructure to go for mediation. So that provision was removed and it was made optional. So parties have the option of going for mediation before going to the court, right? So what we need to do today is to create that awareness, to inform people that you have this option before you, you have a quick way of finding a solution to your problem, try this, if it fails, come to the court. So the Mediation Act provides for all this. It provides for the establishment of mediation service providers. Now because mediation is a very scientific, very nuanced process, it is not simply just making 2 parties sit and talk to each other. You need to be able to handle the parties' emotions. You need to be able to shift their perspective, make them look at different ideas, make them look at their long-term needs, because when parties are angry, their eyes are closed. They are not able to look beyond punishing the other party. Now, is that the most important thing for you? Now, how to do all this? Mediators get trained in that. So it is a very specialized process which you need to do as a good mediator. So you need training for that. So we need to train more mediators. In fact, when I was just getting ready to leave for a training program, I was traveling to, I think it was Hyderabad, when one of my lawyer friends called up and said, he wanted to talk about something, and he said, what are you doing? I said, I'm just leaving for the airport. For what? For a training program. Now, how many mediators are you going to train? He said. I said, I will try to train at least 1.4 billion. Mediation is a life skill.
Exactly.
Right? You learn how to communicate effectively. You learn how to negotiate effectively in mediation training. So the idea is to create a critical number of mediators who will be able to deal with these issues and make some constructive difference in the way today we are resolving disputes. So that's our objective.
As a practicing advocate, I have come across, even without going to mediation or even without taking the help of the court, once I find a good other side, I'll be able to solve the matter.
Yes.
Because once the advocate
Yes.
and the parties oblige,
Yes.
we were able to solve.
Yes.
You will not even believe a case would have taken at least 20 years to settle. We settled. 3 of the lawyers got together and we settled the whole thing.
Easy.
So I'm just trying to ask, like, now you're going to train so many mediators and so many people are going to be well trained. Mediation department get proactive. Like now we can have a survey of the whole country and we can say where the litigation is more. So those areas can be concentrated and such trained mediators can get proactive and particularly choose the place and try to resolve things, because at least 50% may be resolved so that the litigation may come down drastically. So now there are two things, like one, you have to get proactive, at the same time we should have the infrastructure.
Yes.
So you are doing a great service, like you're training so many people and maybe you have resolved so many cases also, because it is a passion for you and such passionate people are there, because I go through the mediation center, I see people talking and trying to resolve, and it's not so lucrative also, but it is more of a passion and service which is happening. So once it gets proactive with a proper infrastructure, don't you think that we'll be cutting down on the litigation totally?
Most certainly. Most certainly, a lot needs to be done. We have been doing a lot, but it's not enough. See, we are a huge country. Okay, and our problems are unique, are different. So we cannot simply just take a Western model and adopt it here. We need to create our own models. And that is where I think we need mediation at different levels. We need specialized mediators who deal with family disputes. We need specialized mediators who will deal with corporate disputes. We need specialized mediators who will be dealing with community disputes. Because at different levels, we need different kinds of training, we need different mediators with different qualifications, with different sets of skills. But essentially, at the core of it are the communication and the negotiation skills. So once we have that, we are able to set up that infrastructure, I'm sure that we'll be bringing down litigation to a large extent. Now, all along, only courts have been involved in promoting this and pushing this. Now the time has come for taking it into the private domain. And I think this is where the corporate sector can come forward as a part of their corporate social responsibility to provide the necessary infrastructure, to create these institutions which can offer the mediation services and encourage people, including their own disputes. See, there are so many things that can be done. Workplace disputes. Employees have conflicts in the workplace itself. Now, these are all disputes can be nipped in the bud.
Exactly.
If you are able to provide mediation option to those parties who are in conflict. That will enhance your own productivity.
Exactly.
You have inter se disputes between different companies. You can resolve that through the process of mediation. See, I'll give you an example. I had a case where there was a claim of 8.5 crores by one company. There was a contract and they were claiming 8.5 crores, and this company was saying only 25 lakhs is available with us after adjusting all the dues from them. We can pay only 25 lakhs. If they had directly negotiated, this would never have got resolved. But you know what happened in mediation? Guess how much it got resolved for? 66.5 lakhs.
Totally.
Totally. It got settled. So you see, there are different kinds of disputes that need different approach, different ways of handling. Husband and wife dispute, you need a completely different approach for that. You can't, deal with it like how you deal with a commercial dispute. You need a different skill set here. So what will happen, how I see this whole thing developing is that, first of all, there has to be a recognition that this is necessary. We can't do without it. We have to adopt it. That is the only way that we can provide access to justice to the people of this country. Here, the administrators, the policy makers, the courts, everybody has to take cognizance of this fact. Okay, because today that understanding exists in only certain pockets. But there has to be a widespread recognition and understanding of that. And that has to be implemented at a ground level. And this has to be encouraged. There have to be more programs. See, private people like us have limitations. Okay, we can go around, we can conduct training, but how much can any one or group of persons do? Now, this is where the administration has to step in and give their support. Okay, today we have, as you rightly said, we have, for example, if you take our own High Court or any other High Court, we have a group of passionate people, people who are so committed to the cause of mediation, to the cause of providing access to justice to people. They are doing pro bono service. They are being paid a very paltry sum as an honorarium. How about rewarding them for their services? How about encouraging them, making them realize that this is a fruitful thing? Because after all, everybody needs money to survive, right? Why not bring mediation as a profession? And that is exactly what yesterday in the conference in the Madras High Court we were discussing. Because it is time for, profession. Mr. Sriram Panchu was speaking yesterday at the conference. He is one of the pioneers of mediation.
Yes, yes.
So he started the first Court Annex Mediation Center along with the then Chief Justice, Justice Markandeya Kadju. And he was saying that we have to professionalize mediation. People have to realize, because youngsters are very interested. See, wherever I go, today I coach students for international competitions. And the team from Nalsar I had coached, they won the ICC Paris mediation competition in 2023. It is one of the most prestigious. They have a natural flair for it because their minds are not cluttered with this litigation concept. Their minds are free. So it's very easy to get them into this, to coach them, to help them to, do this. And they are very interested. They are looking at mediation as a career option. So we have to create that infrastructure to encourage them to come forward and take this as a profession. And that, I think, is the only way we can solve the problems of this country, especially the problems relating to the backlog of cases, the pendency of litigation. Not only that, see, the more important thing is mediation training helps you to develop the culture of dialogue, of listening to the other person, understanding the other person's perspective, right? So this is more important because we need to cultivate this, because we are now actually planning what is called as peer mediation, where we want to go to schools and train children in mediation so that they grow up with those skills that are required to understand each other, to be able to talk to each other, to go beyond their emotions, their egos, and look at each other's needs, recognize those needs, and work with each other to make things better for themselves. That is the only way forward for entire humanity.
It will address the core of the problem, because once they're able to strike some understanding with the children and the future community, I think the litigating attitude may come down drastically.
Yes.
Because that is the high time we start doing that.
We start doing that because it's time that people start looking at each other.
We'll have to tell them, right, at a very young age, don't go to court.
Yes. See, we are talking today about the Vasudhaiva Kutumbakam, right? So when you're talking about Vasudhaiva Kutumbakam, you need to know how that family is created. A family has problems, a family has disputes, conflicts. How do you resolve those conflicts? Because otherwise, how are you a family?
Because I think in every measure, every acts which we are going to take, we should include advocates in that. Because once there is a legal remedy, only they can only advise. Because we should not let the community down. Because as you said, survival is also there. At the same time, there should be a result-oriented thing also.
I'm very glad you brought up this. Now, many lawyers perceive this because there's a very popular saying which says ADR, that is alternate dispute resolution, stands for alarming decrease in revenue. Okay. Now, what we need to understand is that all along, lawyers have been getting trained only as gladiators. You know, with those Roman gladiators who go and fight. So we have been trained only as problem inflamers. See, you come to me as a lawyer, you have a problem. Now, when I take you to the court, because that's the only option there for me, I have nothing else. I can only help you by taking you to the court. Now, when I take you to the court, I have to fit your case within the framework of the law. So I have to twist and distort whatever facts you tell me to fit it into that framework of law. Because I have to get you the relief, right? I'm not doing anything wrong. Because my duty is towards you as my client. So I distort this, I put it down. Now the other side sees this. And their lawyer also does the same exercise. Now we are inflaming the problem. Now what we need to do is we need to change this and train lawyers as problem solvers instead of being problem inflamers. So here is where universities, law universities and law schools can play a very significant role by not just training lawyers in the law, but also in the field of problem solving. How do you solve your client's problems? See, we are like doctors, right? Our profession is like doctors. You have a medical issue with your body, you go to a doctor. You have a social issue, you have a commercial issue, you have a family issue, you go to a lawyer, right? So doctors heal your body and lawyers are supposed to heal your problems, not aggravate them. So we need to start training our lawyers in a problem solving approach. But today we are not doing that. So we blame the lawyers.
We are not able to because, as you said, they have to fit into. Because I remember a case.
Yes.
It was filed in Bangalore.
Yes.
And the format there is: a husband accuses a wife. It's a one paragraph. She goes to the bar. She drinks. She smokes.
Yeah.
And this girl was from a very conservative family in Chennai. That stood in the forefront.
Correct.
They said, how can they say my daughter goes to the pub and drinks?
Yes.
Because that lawyer says it is a format which we use for everybody.
For everything, yes.
So there the thinking goes up because they just want to bring in cruelty and some ingredients.
Make up those grounds.
They make up grounds.
Yes.
So as you said, a disease-free country is healthy.
Yes.
A litigation-free country is more idealistic.
Yes.
So now we are going towards the ideal.
We are moving towards an ideal where at least we are able to solve our problems in a more peaceful manner by collaborating with each other, so that there is an end to the conflict. See, there is what the courts do today is solve a dispute. But beyond the dispute, there is something more underlying. There is a conflict.
Yes.
Right? How do we solve the conflict? Now that conflict comes from miscommunication, misunderstanding, suspicion, distrust, fear. All these factors drive the conflict. Now, let's say the two neighbors. Now the whole dispute is about the boundary wall. Okay. Now if you look beyond that boundary wall dispute, you will find that there's a whole lot of conflict between them. One man is habitually dumping his garbage in front of the house of the other. The other man has a bigger car than this man. So this man is not very happy about it. Okay, his trees are leaning over his garden. So all these things, they are the underlying conflict. So if you look at the dispute alone and give a solution for that, it's not going to solve the problem. So there is a difference between adjudicating a dispute and resolving a dispute. So what we are now doing is simply adjudicating the dispute. We are not resolving the dispute. So when you resolve the dispute, you're also resolving the underlying conflict between them. So we should aim at that, not just look at the whole thing as a dispute and adjudicate the dispute and say Rajkumar is right and Jawad is wrong. That's not the way. Rajkumar and Jawad have a problem. So how do we find a solution to that problem so that Jawad and Rajkumar can live with themselves in the future in peace, right?
You were talking about the pending litigations because government sectors are major contributors to the litigation. And the main reason behind that is once the government sectors or officers represent in mediation, they are not able to take a decision because there are accusations. Even some justices have quoted the Supreme Court that they are frightened of some extraneous things. So is there any new light on this aspect wherein the majority of the litigation can be solved in our bill 2023? Do we have any light on that?
Very good question again, Rajkumar. I'm very happy you're talking to me about all these things and giving me an opportunity to explain this. See, now government is, as you all know, is the biggest litigant in this country. Now when the mediation bill was prepared, there is a first schedule which excludes certain disputes. It says that these disputes cannot be mediated. Criminal cases, blah, blah.
Yeah.
In that, government disputes was included. But when the act came into force, they had removed that. So there is a scope for mediating government disputes. Now here's the challenge. There was one case referred by our High Court. Now, I don't want to go to the details of the case because it will be breach of confidentiality. Dispute between a group of workers and the government. Now, the government, the topmost official, who is an IAS officer, comes for the mediation, asks for a private session with us, and tells us that, look, their claim is justified. But in a mediation, I cannot concede that, because it sets a bad precedent, and tomorrow I will be questioned, why did you concede that? Since this is a private session, let me admit before you their claim is legitimate. If the court decides, the problem is not mine. The responsibility doesn't fall on my head. It's the court's decision, so I will implement it. So I cannot take part in this mediation. Please close it and send it back to the court. Now, this is one of the biggest challenges, because the officials who represent the government, who come and participate in the mediation, are unable to take that responsibility simply because tomorrow they may be held accountable for any decisions that they take.
Exactly.
So that is why we have been having, there has been a lot of brainstorming going on this. And in one of the meetings, Mr. Sriram Panchu had suggested that every department, the government should form committees which will evaluate the cases, agree for the mediation, assess the settlement terms, and see whether they are in the interest of the government also, and if they are reasonable, and what will be the future outcome of the cases, whether the government is going to win or lose. Based on this, if they can, if a mediation is going on, the committee assesses the nature of the settlement that is being entered into, and the government should give immunity to the officials who are taking part in the mediation and who are getting the committee to sanction this. So that way there will be a sense of responsibility and a sense of immunity also in the minds of those officials who are taking part in the mediation process. Unless that is done, government disputes cannot be mediated. Now there are any number of, because governments enter into contracts, there are contractual disputes which the governments have with their contractors. All these can be resolved through mediation. See, there are bodies that are being set up. For example, I am on the panel of Airport Authority of India. They have a dispute resolution board. So any contractor and agency dispute goes before the dispute resolution board for an evaluation, and they make the recommendations. Now what if they are trained in mediation? Or what if it is sent to a mediation service provider, an institution that's providing, so there is an element of neutrality there. So they can they can mediate this dispute and try to find a solution. If that fails, go for arbitration. But imagine the amount of time and cost that you will be saving, right? So this is where I think the government needs to take a call on this. There has to be a policy decision on the part of the government that yes, we are going to take all our matters to mediation. They have to pass the necessary legislations or whatever that is required, frame the rules for that, and implement this process. Because that is the only way that they can cut down on their pending litigation. Because it is costing the government a huge amount of money fighting these litigations. And especially when they go to the Supreme Court, they engage the senior advocates who charge like a taxi meter based on an hourly basis. And whose money is that? That's your money, my money. It's the taxpayers' money. Why should that be wasted in this way? Try to find a resolution. If that doesn't work, go for litigation or arbitration. I think that's the way forward.
Okay, one final question. We need to talk about the unsung heroes and heroines.
Yes.
The mediators. So now they undergo a 40-hour training.
Yes.
They are included in the panel, and subsequently they are called for mediation sessions. So every case is new for them. They are appointed, and they use their maximum. Because I have seen physically. I have been parties advocate at the mediation sessions, and there are so many sincere mediators who try to solve out of, who have very active practice also. They come as a passion and do that. So the mediators themselves, they have some sort of their own character and their own interests and their own convictions. So now while addressing a problem, it becomes a challenge for them. They have a mental setup and something going too much against it may affect them also, mentally and emotionally and everything. So what is the training? Because the basic training, I don't think we need to elaborate here. But here now we have come to the second stage where the mediators themselves will succumb to certain pressures. I have spoken to certain mediators and they feel very drained out at times.
Yes.
So like they themselves need some sort of counseling. Yes. I have felt that. So like how well do you train them on those aspects? Because they are the backbone of mediation. Whichever thing we are going to achieve is only through the sincere mediators who are doing a great job now. And avenues need to be open for them to perform better. Now I think you can all address this problem at levels where we can popularize mediation throughout the country. So now like how do you view that aspect? Like how do they maintain their balance and address the issues?
See, this is where the training becomes very important, Rajkumar, because at least I don't know about how others are doing. In my mediation trainings, the trainings that I conduct, I spend a lot of time on the neuroscience of conflict, on the aspect of the biases and prejudices that are inherent in us, which are called as cognitive biases. Sometimes they are so embedded in our subconscious, we are not even aware of them. And how do we recognize those biases? How do we deal with those biases? It becomes a very important question in the mediation. Because as you rightly said, supposing, let's say that you are mediating a matrimonial dispute. Now you may be having certain values that are important for you, and you're not even conscious that those values are important for you because that's the environment you have grown up in, that's what you have seen, and that seems perfectly normal to you. So the party who's reflecting those values, you may tend to lean towards that party and not towards the party who's opposing those values, right? Now this becomes a challenge for every mediator. Now this is where a significant amount of our training is focused on these abilities to be first becoming conscious of your own bias and then being able to deal with your bias.
Exactly.
Because all of us have biases. Not a single one of us can claim that I am totally unbiased. We all have our beliefs, we all have our notions, we all have our concepts. Okay, we all have our own values, and these are all things that are deep down in our subconscious, we are not even aware of them. Okay, we are not even aware that we are taking sides, right? So it becomes very important for the mediators to work on their own emotional intelligence. The intelligence to understand, recognize what is happening to them, to be able to deal with that, to stay away from it, to be able to recognize that, move from it, and then deal with the other people's emotions. So emotional intelligence is two things. One is that self-controlling ability, and the second is to be able to deal with other people's emotions. So how do you handle those emotions? How do you empathetically listen to them? How do you understand their problems? How do you understand what is their perspective? What are their own biases and prejudices that are dictating their conduct, their behavior? To be able to recognize that and to be able to help them to understand it. That is called as empathy. So large part of the training is focused on these two elements. On the emotional intelligence part, on the ability to recognize your own biases, and how do you help parties without questioning their beliefs? How do you help them to look at each other's perspective and come to a solution that would be workable for both of them? Now this is why training becomes essential, because people don't understand what a scientific and nuanced process the mediation process is, why it is structured the way it is structured. Why do you have a mediator's opening statement, for example? Because we emphasize a lot when we are training mediators on making that opening statement. Because parties are coming to you in a state of high conflict, highly emotional stage. How do you calm them down? How do you make them feel relaxed? How do you develop the trust? Because they have to trust you. And you are going to be asking them for a lot of confidential information. Why should they share that with you? Now, all these become a challenge.
That trust has to be.
Yes. So, yeah, we talk about two kinds of trust. We talk about strategic trust, a trust that you will have in a professional, and we talk about emotional trust. the trust that you would have in a friend or a spouse or a family member. Now, how do you take parties from that strategic trust to the emotional trust, where they are able to discuss everything with you, very honestly and frankly? Now, these are the training components in a mediation, okay, in a mediation training. So we focus a lot on that.
Good.
And try to develop those skills in the mediators. Now, a lot of people have an aptitude for it, especially the young people. They adapt to it like fish to water. Now, I always give the example of how, people like us, the old people, not you, I mean
no.
me. Yeah.
Stick to that.
Good. So we have already, because we have lived for 50 years, 60 years, and we have these edifices built in our minds. So when you train an adult who's lived for 50, 60 years, you have to demolish that edifice and construct a new one. Whereas for the youngsters, they have no such thing. It's a vacant plot.
It's raw, totally raw.
You can construct the edifice straight away, and you can prepare them to be good human beings. See, being a good mediator means you're a good human being.
Exactly, yes. At least while you're a mediator.
Yes. No, even otherwise.
Otherwise.
Because you can't suddenly switch from a bad human being to a good human being when you're mediating alone.
That's a good
You
compliment.
apply all those skills, all those values to your day-to-day life. That is why mediation, we call it as a life skill, where it not only helps you to deal with other people's problems, it helps you to deal with your own problems.
Exactly.
And it made a significant difference in my own life. And luckily for me, my wife is also a mediator.
So two good people in one house.
Two good mediators in one house. Trying to be good people.
Good.
Okay.
And I really want you to say, like, the outcome of our conversation is like, we would wish you to, as soon, to speeden up the process of popularizing mediation, where most of the people can be benefited through that. So what will be the message, or how do you think it can be done? Because now you have to move in a lot of things, because it needs funds, it needs manpower, and it needs a lot of infrastructure to do that. So how soon do you think that this can be possible? Because we want to get rid of maximum litigation so that it is beneficial to people. So the litigation is real frustration for people now. Because I see in my experience also, like, people are so frustrated. The delay is the main frustration. Because once you have the procedural, the cumbersome procedures to be taken, or the rights of appeal is curbed to some extent. Because the reliefs never reach the people, because we feel happy at one point of time. Again it goes on appeal, and again the second appeal, and again Supreme Court. And it doesn't solve the thing. But that kind of a shortcut where the people can rejoice. So now your final message should make the people rejoice, because mediation is one savior according to you, but you need an amount of compromise on that. At the same time, how do you think it can, because it reach people first?
See, I think this is, we have come to the stage where we have the legal framework for it. All it needs is a collaborative effort from the courts, from lawyers, from parties, litigants, and from those sections of society, especially the state, the government itself, as well as those sections of society that are dealing with day-to-day conflicts. You have the police department, you have various other departments of the government. Now, all of us have to work in tandem to promote this. Because the value of this, the importance of this, we have to recognize. And once we recognize that, we should all work together to promote this as much as we can. Courts have been doing their part. Okay? We mediators have been doing our part. Now we want more people to come in. We want it to be widespread. Okay? We want universities to step in. Okay? We want government departments to step in. And we want this to be implemented at a much bigger level. See, we have a few, because now, see, there are two kinds of training. One, what the courts do, and the other, what private institutions do. Now, I'm a part of training for excellence in arbitration mediation. It's called TEAM. So we offer mediation trainings to law students, to professionals, and I have had people who have been retired IAS and IRS officers. I have had clinical psychologists. I have had academicians, Last time when I did a training in Hyderabad, the dean of the Osmania University's engineering college was attending the mediation course, because all these people are dealing with conflicts in their day-to-day life. Okay, doctors are attending now. So we have to spread this far and wide. Okay, so we have to, first of all, develop the training institutions. We have to have more training institutions that will be offering quality training, not just naam ke vaste training. Okay, we need quality training, and quality training can be delivered only if people can afford to take out that 5 or 6 days time, attend the training so that they can get the full benefit of it. And it is a life transforming experience. Many of the people who have attended the training have told me that we feel our lives have changed. Because it changes the way you look at life, it changes the way you deal with problems, the way you communicate with each other. So that will be the first step, because we need to create the infrastructure. And we need to promote institutional mediation, because we need to establish quality institutions that would be promoting mediations. Okay? So this is the kind of work that requires a very sustained and very committed push to really push forward this agenda. We have no other alternative. I strongly believe we have no other alternative. People are losing faith. People are losing faith in systems. People have already started taking law in their hands. So before it crosses the limit where we cannot, before it breaks down into total chaos, total anarchy, I think we should step in and start doing this very seriously. So at different levels we need to implement these. So I don't think there is any other alternative for it. My appeal through your program to people from different walks of life is, please come forward. This will be a great service that we will be doing to the country, to the nation. Take this as a national service. Corporates can take it as part of the CSR and see how best they can implement this, popularize it, make it stronger, and make it as the mainstream dispute resolution mechanism. So I don't regard mediation as an alternative. Mediation should be the mainstream. That should be the port of first call. You have a dispute, to go for mediation first. If that fails, then you go to the other alternate dispute resolution mechanisms like the court or arbitration.
It was a very, very useful discussion today, and I think we are still in the threshold of
yes.
Towards the next step, because
we have come a long way, but
still a long way to go, and maybe like a bamboo which shoots up.
Yes.
It stays inside the ground for a long time and suddenly shoots up. Let mediation also have the same characteristics and get big soon. So thank you so much.
Thank you, Raj. Thank you so much.